then you'll find by looking at that report that in actual fact, you're not the only one. I think when we ran the survey back in May, only 29% of the businesses surveyed had actually actively started with their compliance. But certainly that is quite a worrying statistic if that continues. So if you're interested in the report, it is there in full, and it does have some sort of sector-specific things in there. Also, the website, if you're at all interested, it does have things like an overview of GDPR, a fines calculator, and a daily countdown, which I do check on a daily basis to make sure that the countdown is working. So that may help you in terms of looking at what the impact might be. So it is happening on the 25th of May, as I say. It's European legislation. What that means is that essentially it does raise the question as to what does Brexit mean for it. I think there's a lot of misunderstanding as to how Brexit's going to impact upon it. We did an article with the Telegraph, and I went onto the forums afterwards to have a look at what people were saying. And essentially, a lot of people were saying, well, that's all very well, but Brexit will obviously mean that we don't have to comply with GDPR and it will fall by the wayside. That's by no means the case. And the reason for that is that the Queen's speech has completely put that issue to bed. It was always going to happen, and the government had stated that it was going to happen, but there was still a lot of confusion around it. But the Queen's speech has said that there will be a data protection bill. And that data protection bill, whilst we don't have the detail as to exactly what will be in it, the background to the Queen's speech, the briefing notes that came with it, have made it clear that it will say that GDPR will be happening. So that completely puts that issue to bed. So in terms of what the content of the legislation is like, it is meant to be pan-European, so it is meant to level the playing field across Europe. It has been agreed amongst all EU member states, and if you can imagine that trying to get 20 plus member states to agree a piece of legislation, you can imagine what a challenge that has been. What that means is that there are fairly broad statements in GDPR, and it doesn't necessarily have the black letter law that we would be used to in the UK. So that means that guidance is very important, because from a European perspective, not only do you have to comply with the letter of what's there, but because it's written in broad terms, you also have to comply with the intent. So you need to have one eye on the guidance in order to understand what that means in terms of the intent. There are two sources of guidance that I would recommend to you. The first is that's issued by the UK regulator, which is the ICO, and there's also some pan-European guidance which is coming out of the Article 29 Working Party. Unfortunately, the guidance isn't coming out very fast. So I'm afraid I am going to have to sort of say to you that while we have the core of what GDPR says, you'll have to sort of build in some level of flexibility into your compliance program to enable you to accommodate guidance as and when it comes out. And some fairly important things are being dealt with as part and parcel of the guidance. So I'd very much flag that with you. The other thing that means that I can't definitively tell you exactly everything that you need to do from a GDPR point of view is that the exemptions, the majority of them have not yet been set. A lot of them are left to national law, and so the UK government is deciding what those exemptions will look like. We are not anticipating that the exemptions are particularly broad, and certainly that's the view of the Information Commissioner, that they shouldn't be broad. She is wanting them to reflect the current position. So anybody that's sort of rather hoping that it will say that all businesses under X million turnover will be outside the scope of GDPR, or if you have less than I don't know, 50 employees or something, you'll be outside the scope of it. That's not the sort of exemptions that we're going to be looking at. Essentially, the exemptions are going to be very similar to the sorts of things that we have now. So, for example, anybody that has ever relied on the exemption allowing the disclosure of personal data for the purposes of litigation, it's that sort of narrow exemption that we are likely to be headed towards. So it is a little bit of a case of watch this space. But we do have the core principles of what GDPR means. Before we launch into the practical steps for compliance, I think it would be quite useful to take a step back and have a look at some of the terms that are used quite a lot, particularly if you're going to go and have a look at the guidance that I've recommended, because these terms are freely used. What I will say is that the ICO guidance, the UK guidance, tends to be more user-friendly than the Article 29 Working Party guidance, which can be a little bit technical, but it is very detailed. So you need to understand the difference between what a data controller is and what a data processor is. A data controller is essentially the business or organisation that decides what data is collected and how it is used. So from the point of view of your business, in terms of your deciding what your employee data you'll collect, how you will use it, potentially what happens with candidate data, information in relation to your clients, you are making those decisions. So on the basis that you are making those decisions, you'll be data controller. You also need to, however, understand what a data processor is, because I would strongly suspect that you will also potentially be a data processor on behalf of some of your clients, and you also will be potentially engaging data processors in relation to your suppliers. And I think one of the things that is quite important is, and we'll have a look at it more in the context of contractual arrangements, is what hat are you wearing at any one time? Are you data controller? Are you data processor? Are you dealing with a data processor or a data controller?
So it's interesting you say that actually, Joanne, because I know one of the questions we've got is that often with recruitment agencies, a client will say, oh, please can you collect this data? We really want to do something on diversity, or please now start collecting this data. If the client asks, please could you start collecting this data, and you're the one that starts collecting it, is the agency in that scenario the data controller or the data processor?
I think that's an interesting one, Belinda, because I think anything that you are doing on behalf of the client, as their sort of agent or as their sort of subcontractor, if you want to categorise it like that, you would be regarded as a data processor, which means ultimately compliance will track back to the client. If you are deciding to do that, then you are data controller. And this is why I'm sort of recommending that you think about, in any given situation, which hat are you wearing? Because I think, particularly from a recruitment agent point of view, I think you will be wearing multiple hats in relation to data streams. And I think understanding what you are in a given circumstance is quite important, because the point of it is that data processors, whilst they have direct obligations under GDPR, primary compliance does sit with data controllers. And so it is important to understand where you are. It's also important to understand from your supplier point of view whether or not they're data processors, because there are express obligations in relation to the content of the contract that you have to have with data processors. And equally, that will apply if you're a data processor, in that you need to make sure your contracts with clients include the necessary provisions. So I do think it is one of those things that needs some quite careful consideration.
Great. No, I think that'd be really useful for everyone on the call, because that just comes up all the time, I think, in that recruitment agency relationship.
And I think, and the other thing as well is, I think even in an agency relationship and in one contract, you can be wearing two hats in a contract. And equally, it may well be that both parties potentially wearing a processor hat at some point, or controller hat. And so you potentially need to deal with that. And there are, you can build flex into a contract in terms of, say, to the extent that we're acting as data processor, will apply to the extent we're a data controller. But we can have a look at contracts in a bit more detail later. But yeah, you're absolutely right. Understanding where you stand on that sort of line is quite important. So, looking at what is covered by GDPR, it's essentially a reform of the laws relating to personal data. There are some complex sort of provisions and discussions, quite esoteric amongst lawyers as to exactly what comprises personal data. But I think, to be honest, in a nutshell, the easiest thing to think about is it is information relating to a living individual. So it potentially could apply to your employee data, pensions data, candidate data, information that you hold on individuals within a client. Also, if you are dealing with sole traders or partnerships, even in a business context, they are regarded as individuals because they don't have separate legal personality. They are not a corporate. So they would be covered by GDPR and get the same protection of GDPR as individuals. The regulation applies to the processing of personal data, and sometimes I get asked as to, could you argue that what we're doing is not processing? I wouldn't go down that route, because essentially processing is a cradle-to-grave definition, and it covers calling data up on screen, amending data, interrogating data, sending data on. It's a very, very broad definition, and I don't think it would play out well with the Information Commissioner, and I wouldn't suggest you try and put together any arguments that you're not actually processing. The intent behind GDPR is that it's technologically neutral, and the reason for that is that there is a feeling that the Data Protection Act 98, which it replaces, is out of date. The 98 Act, just to give you a bit of background, I think they started to talk about it in 95, and then it was obviously picked up in 98, which is fine, apart from if you think about the fact that this year is the 10th anniversary of the iPhone. So when they were legislating back then, smartphones weren't in existence, big data wasn't in existence. And so they feel that it's out of date in terms of, from a technological point of view. So what they've tried to do is future-proof GDPR to some degree and made it technologically neutral. So it references the use of personal data, the processing of personal data via automated means, so on computer, or any other form of automated means that might come in the future, and by non-automated means. So if you have structured paper files, then they will also be caught by GDPR, which hopefully isn't news to anybody on the call on the basis that that has been the case under the Data Protection Act, but it's certainly emphasised under GDPR. The last definition that I think is useful to understand before we launch into the more practical steps is the difference between ordinary personal data and sensitive personal data. Different standards apply to the level of protections that are applied to ordinary and sensitive personal data. Sensitive personal data gets a much higher level of protection. Under GDPR, it will become known as special categories of data. And I think in terms of understanding what falls within what category, it's probably best to start with sensitive or special categories of data, simply because that's a more defined list. And under GDPR, there is a list of the types of data that fall within the definition of sensitive. So that would cover things like health data, ethnicity, religious views. Also, it will cover sexual preference and things like that. So any data that's being captured in relation to that is regarded as sensitive personal data. Also, it's probably worth bearing in mind that GDPR has changed that definition from what is under Data Protection Act, so it includes things like biometric data. So anyone that uses biometric security or access, then you need to bear in mind that that data has very firmly become sensitive or special categories of data. The other thing that they have thrown in there is that philosophical beliefs are sensitive personal data. I don't think anybody's entirely clear what that means, but somebody did suggest to me the other day that if you think you're a Jedi, then that might be your philosophical belief. Anyway, I think that's we'll see how that pans out.
So on the biometric thing, a lot of our recruitment agencies might be running time and attendance systems, some of our larger ones on behalf of clients, where people like clock in and clock out. Other agencies, we have people who might be pickers, say like someone like an Amazon fulfillment centre, and obviously how fast to get around the warehouse. Is that the kind of data that's potentially sensitive?
I think it's things like fingerprint or retina scans and things like that they're considering to be biometric. It will be useful for them to give a full list of what comprises biometric, because it's going to fall into this higher level of protection if they can issue guidance to say exactly what it is. But certainly the examples that have been given today have been things like fingerprint recognition, retinal scans, stuff like that, which some people do use in relation to security aspects.
So rather than your sort of clock on, clock off type thing? Yeah, I guess. Okay.
So sensitive personal data gets an extra layer of protection, as I've said. Ordinary personal data is essentially everything else, which raises the question in relation to financial data. Technically, financial data is ordinary personal data, but it does get an extra layer of protection, and this is confirmed both by our regulator and also by the Article 29 Working Party. So that if, for example, you have a data breach which relates to financial data, that will be regarded by the ICO as being much more serious than if you have one that relates to, I don't know, revealing names and addresses or something of that nature. So it's always worth thinking about financial data as being either a hybrid sort of category or sort of even thinking about it in a very similar way in terms of the level of protection that it gets to sensitive personal data. You don't have to jump through the same gateways, and we'll talk about gateways in a minute, but it does need an extra layer of security than ordinary personal data. And I think it's quite interesting that financial data is just ordinary personal data, because I think if you ask the man in the street whether they were more concerned about their religion being disclosed or their credit card details being disclosed, you can guess which one they're likely to be more concerned about. But it is ordinary personal data. So now moving on to the more pragmatic steps in terms of what should a compliance program look like. I'm very firmly of the view that in order to
we've just got an ice cream van pulling up. It's a very hot day here in Knutsford, so if you can hear the chimes, we're very sorry, but I'm afraid it's not coming round to your offices. Yeah, rather eclectic sound there, so bear with us, you'll probably chime off as he goes away. Sorry about that, Joanne. It's a new one for you, isn't it?
Some have been interrupted by an ice cream van.
She's obviously worried about the data protection, about raspberry ripples.
So I think what you need to do is you need to understand what data you have. You can't become compliant if you don't know what you've got. So I would strongly advise that you carry out a data audit. And that can be done in a number of different ways. There's no prescribed way of doing it. You can do it via a self-help questionnaire. You can interview everyone in terms of within key departments within the business. You could engage somebody to do the interviews. It's just a matter of understanding what you have. What data streams do you have? You then need to consider, well, how am I permissioned to use that data? And there are certain gateways that we're going to have a look at in a minute which allow you to use the personal data. If you don't fall within one of the gateways, you should not be using it. There are also record-keeping requirements under GDPR. There are a lower level in relation to small businesses of under 250 staff, but generally there are obligations that detailed records are kept of data streams, and there's a list of things that have to go into the record. So understanding what data you have will feed into your record-keeping requirements. The reason the record-keeping requirements are there is partly from a transparency point of view, which we'll have a look at, but also from the concept which underpins GDPR, which is not only do you have to do the right thing, but you've got to document the fact that you're doing the right thing. You've got to demonstrate it. And there's this whole idea of accountability in terms of demonstrating through documentation. And by the end of this, you'll probably think I'm obsessed with policies, procedures, documentation, but it is very important from a GDPR point of view. It's also very useful to document your thought processes, because potentially if a complaint does go to the ICO, and you can indicate that you thought about data protection very carefully and that you were trying to do the right thing, then you were quite likely to get brownie points. I can't say that you won't be fined, but at least if you've demonstrated that you were trying to do the right thing, it will be something that you will at least get some credit for. So I do think documentation is very, very important. And I had a client once that said to me in terms of, can you come in and have a look at our data protection situation in terms of where we stand? And they said, but it's brilliant, Joanne, because the ICO will never know what we're doing because we document nothing. That is not the approach to take, and so I very much advise that paper trails are the order of the day from a GDPR point of view. I was talking about having gateways in terms of use of personal data. And there are different gateways in relation to the use of ordinary personal data and different gateways in relation to the use of sensitive or special categories of data. I've summarised what those gateways are in relation to ordinary personal data. And you'll be relieved to hear I'm not proposing to go through each one in any great amount of detail. Safe to say that there is very much a view from a data protection point of view that consent is definitely the holy grail of authorising use of personal data. I don't like consent. I think consent, apart from in certain circumstances, should be at the bottom of the list when you're considering which lawful purpose applies. You should work through everything else before you get to consent. It's very relevant in the context of marketing, and it's relevant in the context of sensitive personal data. But in relation to ordinary personal data, which is not marketing, as I say, I would put it at the bottom of the list and try and find another one first. The reason for that is that consent can always be withdrawn. It can be withdrawn at any point. So if you are using data purely on the basis of consent rather than any other purpose, if the individual withdraws that consent, you've got to stop using it. It also triggers the right to be forgotten, which is something we'll have a look at a little later. But consent, as I say, in my view, should be way down the list. So in terms of looking at the other ones that may help you from the point of view of a business, is you'll see that there is compliance with a legal obligation. That may well help you in the context of your own employees or any statutory reporting that you have to do. There's necessity for performance of a contract. That is also pretty useful. So if you think about it in the context of how you would pay staff, obviously staff like to be paid, so taking their bank account details is important in terms of performing the contract. Equally, if you order something from Amazon, you need to give them your delivery details so that they can deliver the parcel. All that data is being processed on the basis of necessity to perform the contract, not on the basis of consent. Similarly, legitimate interest, that's a really useful gateway for use with a business. Legitimate interest can cover a very broad range of activity, and because of that, privacy campaigners did not want it to be included in GDPR. They wanted rid of it. Fortunately, it has survived, and I think that's great news from a business point of view, because legitimate interest does permit quite a lot of things to be done. There is some guidance issued by the Article 29 Working Party as to what comprises legitimate interest, and it's quite interesting. And essentially what legitimate interest is what you are proposing for the legitimate interest of the business, and this is the important part, can you show that you're not riding roughshod over the privacy rights of individuals? There is more of an emphasis on the rights of individuals under GDPR, and certainly there is a subtle change in wording which shifts the emphasis in relation to legitimate interests. And so one of the things that I would say is that anyone that doesn't want to do the analysis of lawful purpose because they think they've done it from a data protection point of view, I would caution against this, because there is changing in the wording of the gateways, and you might find yourself not actually falling within it anymore. So it's always worth doing the analysis again. Quite often it's quite clear from a legitimate interest point of view whether or not what you want to do is for your legitimate interest, but is not particularly invasive or intrusive from a privacy point of view. Sometimes it's not quite so clear. What I would suggest in that situation is, if you're faced with that in terms of how you're going to sort of process data maybe for a new system or a new service or whatever, it is worth doing a weighing up and a balancing act between the two. And the guidance, that the Article 29 Working Party has issued on legitimate interest essentially sets out all the things you need to think about when you're doing that weighing up act. So anybody that's faced with a difficult decision, it's worth working through that list of things that you need to weigh up and documenting why you came to that decision. Because if you haven't come to the same decision as the ICO, at least they can see your thought processes and they can see that you were very serious about ensuring data protection compliance. So looking at consent, if you are in the realms of consent, then consent under GDPR is very different. Under the Data Protection Act, a number of people used implied consent. People tried to argue that they're useless on the basis of implied consent. Implied consent under GDPR is dead in the water, to be perfectly honest. Any consent under GDPR has to be unambiguous, freely given, and there has to be clear affirmative action. So having a pre-ticked box or having implied consent is not something you should be doing from a GDPR point of view. You can get consent via a box, but you have to get the individuals to tick the box themselves rather than pre-ticking. So you don't need everything signed in triplicate and in blood, but you do need them to actually do something. As I've sort of already said, consent can be withdrawn at any point. One of the things that has been made clear is that if you are seeking consent for a number of different purposes, you have to have a separate tick box or a separate confirmation in relation to each of those consents. You also, if you are getting someone to accept your terms and conditions, need to have a separate tick box in relation to your data protection consents to your I accept your terms and conditions box. So the days when there used to be a single tick box and a very short paragraph in terms of I accept your terms and conditions, and I also allow you to do what you want with my personal data and share it with selected third parties, who quite often aren't that selected, that has long gone. Now,
if a recruitment agency scenario, Joanne, you might have people who, there'll be a job on a website. I don't know, we're still doing Monster, but if you're on Monster and someone's applied and that job's gone, would that mean then, in order to sort of take that person on board to look at other jobs and to email them about other jobs and say, well, I'm sorry, that job's gone, but we've got this one, would they have needed to almost consented first and foremost to that? So I submit my details for this job and tick any other jobs, because that's a really common scenario in the recruitment agency.
I think it is, and I think you need to be clear with people what you're going to be doing with their personal data. And I think consent is probably a good idea in that situation. It might be arguable that if you put enough transparency about your privacy policy that you would store it for these additional jobs, that might be enough. But I actually think you're right, Melinda. I think consent is the right way to go on this, because you may well find that somebody is keen on a particular job and that they don't want you to add them to your database generally in relation to other ones. So I do think consent in that situation. And I think consent, when I'm sort of saying use it as a last resort, it's more, you use it where it's slightly unexpected or people may not want to do it, or from a marketing point of view. So where you're giving people an active choice, then I think consent probably is the way to go. And I think you're right. I think that's a good idea.
So in that scenario, it would almost be like, if you really want to make sure you're as watertight as you can possibly sort of future-proof yourself, you would almost have that two-box thing, this role and other roles of a similar thing. Because, most recruitment agencies, if you're applying for a warehouse job, you're not applying for an accountancy job, so as long as it's broadly in the spectrum, you've applied for a warehouse job, you're quite happy probably to get other warehouse jobs. You're not suddenly getting, something super random.
Yeah.
Okay. I know that's been a question that's come up a lot on our previous webinars. I hope that's a real help to everyone on the call, because I think that's definitely one of those key ones for the recruitment agencies out there.
I think, as you say, if you want to be squeaky clean on it, then I think you give people the option. And certainly if you don't want to give them the option, at least you need to give them the ability to say no. So it's like, please don't consider me for any other roles. But I think you're right. I think the actual consent in terms of please include me for other roles would be better. One of the things you'll see on the slide is that there's a reference to it's not available where there's clear imbalance in the relationship. And there was a lot of discussion on that general statement when GDPR was being passed. And essentially, it was primarily in the context of an employer-employee relationship. So in relation to your employees, to whether or not consent can be used to legitimise the use of personal data. It was something that was left to national law. And recently, the ICO has issued some draft consent guidance in relation to what their views on consent should look like. It is draft, so we'll be, I can't definitively say that this is what it's going to look like. It was meant to be approved last month, but we haven't seen anything to say it has been approved. And it was subject to quite a lot of consultation and views because it was relatively controversial in a number of respects, so there was quite a lot of feedback in relation to it, and certainly some of our clients asked us to do it on an anonymous basis in terms of concerns that they had. What that consent said in that context was that you cannot use consent in an employer-employee relationship. Now, what that doesn't mean is that you can't use the personal data at all. What it means is that you've got to find one of the other gateways to permit its use. So it shouldn't really change things dramatically. What it will change is the content of potentially employment contracts, new starter forms, things like that. Because if you are taking consent, then that is not where you want to be with this. As I say, it's a bit watch this space. And unfortunately, from an employment point of view, there's a lot of things that are watch this space because it's one of the areas where we're really wanting additional guidance and we don't yet have it. But it is worth at least putting that on your sort of to-do list in terms of revisiting that as soon as it comes out. One of the things that the consent guidance also says, and you'll see it at the top, in terms of echoing the sort of point that I've been making, is that the ICO, one, isn't hugely keen on consent except where you definitely need it, and also not wanting people to continue doing what they're doing at the moment. And what quite a lot of people do is that they decide that, for example, it's a necessity to perform a contract, so they've got that gateway in their pocket, but also in their back pocket in order, as a guarantee, they're going to take consent because then you can't possibly be wrong. The ICO doesn't really like that, and certainly under this guidance, if this guidance stands, because what they're saying is that you're misleading people. so that if you're asking for consent, people think they can say no, but if you're going to use it anyway, then you're misleading people and it's not fair to do that. So you really need to nail your colours to the mast in terms of what you're doing. And if you're going down the consent route, then it is consent and you are genuinely giving people the option to say no. If you are not giving them that option, then you need to look for one of the other gateways.
That's really interesting, actually, because I think, again, there's lots of scenarios where, recruitment agencies would say, we've been running seminars this morning on modern slavery. So I think at the pool, we would say it's really important that all our agencies who have contracts with us have access to modern slavery training. And we would say we think that's necessary for the performance of the contract. But then at the same time, if I emailed out as a marketing person to say, oh, we've got these seminars, do you consent to having your details to write about seminars? In that case, I should really be saying, you know what, this is absolutely, these seminars need to happen, people need to know about them because it's really important for the performance of the contract, ethical trading, etc. And I would just choose that option. And I think a lot of our agencies obviously run seminars with clients where because of their contract with their client, have to do certain things.
Yeah, I think it's a question of, are you genuinely giving somebody the ability to say no? And if you're not giving them the ability to say no, can you genuinely say it's a legitimate interest of the business, so it's a necessity to perform the contract? And if you can, then no, you don't have to give them the option. If you're struggling in terms of getting through one of the other ones, then you probably are in the territory of giving people options.
Yeah.
So I think it's just taking that step back and thinking about it. One of the other points that is on the slide, which the ICO has sort of nailed her colours to the mast on, is how often you have to refresh consents. Before, and when people used to ask me when do consents need to be refreshed, you sort of gave the typical lawyer's answer of, well, it all depends. To be honest, that was never very helpful for anybody, and the look of disappointment on their face when I sort of gave that was quite clear. I think it's quite helpful that they have said that at the bare minimum it needs to be every 2 years. Obviously, it's a short period of time, which is the sort of unfortunate part of that. But what that means is that if you are operating on the basis of consent, you need to have a system of recording the consent, because you need to record the date on which you got it to make sure that you can also then track when you refresh it. So I do think that does need some thought in terms of from a sort of how you're going to underpin that and the process that you're going to use to do that. One of the other things which proved to be one of the very unpopular parts of the consent guidance is that if you are sharing data with a third party on the basis of consent, you have to name them by corporate name and have a separate tick box for each one. So essentially, potentially what you could have gone from is one tick box to a huge long list of tick boxes that you're expecting people to tick. So that is something that is worth some thought, and we'll wait and see what the ICO says in relation to that.
So again, so our recruitment agencies are very specific examples. That might be some of our larger recruitment agencies, could be different brands in the network, slightly different entities. They might own an umbrella company, I don't know. There could be like different people sort of. So in that case, you would say, okay, you consent to me, Recruitment Limited, getting it. Also, this umbrella company plus this, and you would literally list them all out.
I think that raises an interesting question, because one of the questions we asked when we fed back on the guidance is, what about group companies? Because you can sort of see if it's, sharing with somebody completely different. But a group company, are you bothered if there's an umbrella brand? Is it the brand or is it the company in terms of the entities? And I think it would be interesting. I think on a strict reading of it, Belinda, you're absolutely right. And potentially, intra-group sharing would be something we need sort of additional tick boxes for. But hopefully, it might be okay in terms of if they think about it in the guidance. But again, it's a bit of watch this space on that one. But I think it is a very, very relevant issue. And when I said that we'd fed back for a number of clients, a number of them had raised that in terms of we have group structures. We send it around the group. We really don't want to have to be saying, not least because obviously some corporate entities have different names to the people that they operate under the same umbrella brand. So it would be interesting to see how that sort of pans out.
Yeah, because I think in the recruitment world, you might even have the same database. I've worked in companies where, it's just like literally just a flick of the screen, but actually everyone could probably access the other parts of the data. So.
And I think, again, you're back on the basis of, are you doing it on the basis of consent, or are you going to do it anyway? Are you allowed to do it anyway? And if you're allowed to do it anyway, then it becomes a transparency issue in terms of giving information rather than seeking consent. So again, back to my point about, are we in consent territory, are we not? And this is one of the other reasons, in terms of the complexity of what a consent needs to look like under GDPR, which is why I'm saying, potentially put it to the bottom of the list. It's only if you can't make the other ones fly that you go down the consent route. The other thing is that consents have to be detailed, a lot more detail in the consents in terms of what you're seeking consent for, because if you don't give people enough detail, then it won't be a valid consent. So the ultimate sort of message that I'm giving you is that I would strongly suspect that most people's consents are not GDPR compliant. You do need to look at your consents and redraft them. In terms of things being under the spotlight from a consent point of view, anyone engaged in the marketing space or promotional space in terms of sending stuff out, there have been 3 companies who've had a problem with this, in that they sent out a mailer to their customers in which they asked them to update their contact details, etc., to make sure that their database was fully updated for GDPR. What they also did, in terms of somebody thinking it was a great idea, is that it took marketing preferences as well on the bottom of that. Now, that would have been okay if they'd just sent it to people that had opted into marketing, but they blasted their whole database with it. And as you can imagine, people that have chosen to opt out of marketing tend to get quite excited if they then receive the marketing and get upset about it, and they complain to the ICO. And that resulted in, for one of the businesses, a £70,000 fine. And so you do need to be quite careful. So if you've got anybody suggesting that you couple any marketing consents and things on the bottom, and you haven't already got marketing consent, be very wary where you're sending it to. In terms of finalising where we are on the gateways, then the next slide looks at those which are relevant to sensitive or special categories of personal data. I'm not going to go through them, and they are very much a summary of what they are, but it's just worth noting that they are different, and consent is much more relevant in the context of sensitive personal data. You'll see that explicit consent is listed at the top. Moving on to transparency, being clear with people about what you are doing with their personal data is a key part of GDPR. Currently, a lot of businesses will fill in the ICO registration document form, whatever you will, and get a notification, pay their 35 quid, and think that that is data protection compliance. And we see that quite a lot. I have corporate colleagues, and I assist on in terms of doing due diligence in corporate transactions, in terms of what data protection compliance is like. And you sometimes get businesses to say, no, we're fully data protection compliant, we have a notification with the ICO. That is very much a misconception, and to put that one to bed, what they've decided to do is to actually get rid of that notification process, and instead say that you're going to have to be clear with people about what you are doing, so that you need to there are record keeping requirements, which we've talked about, and you also need to be very clear in your privacy policies and fair processing notices about how you're using personal data. GDPR has got a list of mandated information that needs to be included within them. It has some fairly standard stuff that you would expect, like the identity of the data controller. It has some more unexpected stuff that is not something that you would normally see in a fair processing notice or privacy policy under a Data Protection Act point of view. So, for example, data retention deadlines and things like that. That is not something that you quite often see. I've delivered a variant on this talk probably now to around about 800 people, various different locations and various different guises. And I've always asked the question in terms of, does anybody provide the things like retention information? And one person out of all of that sort of put their hand up and said they did. So it is a brave new world in terms of the content of these things, and I would definitely recommend that you have a look at the list of things that you need to hit. You'll also see that it says and any other information to make the processing fair, which is incredibly helpful, but essentially it's anything to tell people what you are doing to make it clear. The information that you provide in the fair processing notice has to be concise, and it has to be easily accessible and in plain language. The section which deals with the obligations to provide it in plain language is headed Transparency and Modalities, which, to be fair, modalities foxed me for quite a while in terms of what that applied to, but evidently the obligation about using plain language does not apply to the European Commission. So essentially you need to look at the content So you're going to have to communicate more information. You're going to have to communicate it in plain language. You will also have to think about your audience. So you need to think about the demographic that you're addressing it to. Is it meaningful to them? One of the things that the ICO is suggesting even now under the Data Protection Act is that you road test your privacy policies. So that essentially, when you have redrafted them or drafted them, that you get somebody that it's sort of addressed to, and that you ask them to read it and see if they actually understand it. Because generally it's the case, I draft these things all the time. So I understand what they mean. Client generally understands what they mean. Whether or not the person they're addressed to understands what they mean is a sort of whole different issue. And so this is something that the ICO is very keen on doing. And if you do that, then I would strongly advise that you document the fact that you gave it, say, 3 people to whom it was intended to be addressed, and that all 3 of them said, yeah, no, I definitely understand what it's intended, and it's meant to say this, 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 and this. You'll see that I've mentioned on the slide the use of layered policies. Essentially what I mean by that is you also need to think about how you're communicating the information. So for example, if you are communicating information to a candidate about how you are going to be using their personal data, it may well be the case that they pick it up on their mobile in terms of if they come onto a mobile site. Now if they've got it on a mobile screen, if you think about the size of a mobile screen and the sort of information that I'm saying that you need to communicate, you're essentially trying to communicate war and peace on a teeny-weeny screen with teeny-weeny writing, which isn't particularly meaningful to people. So what the ICO has suggested, and they are keen on, is that you think about it in terms of what can they read on the screen, what should you make available as being the crux of the message, and then making the rest of it available via sending an email or a link or something of that nature, so that they can pick it up later. So it is a matter of, I think the key to sort of revising your fair process notice and privacy policies is thinking who are you addressing it to, what do they understand, how are they going to be reading it, and sort of take a step back from that point of view. You'll see that the final bullet point references icons, and I sort of put a question mark after it because it sort of appeared in GDPR. It's the first place I've seen the concept of icons in drafting because, you know, I've drafted for a lot of years, but I don't draft in pictures. So I was a bit foxed by that and sort of wondered whether it was sort of smiley face if you're using data in a compliant way or sort of sad face if you're using it in a sort of intrusive way. But in actual fact, the Information Commissioner has already said that icons are a good idea. They've issued their guidance, as I say, on Fair Processing Notice under the Data Protection Act, and they've said they think icons are good. And what they've said, which is quite interesting and it makes a lot more sense, is that people use visual prompts in terms of cues, in terms of content, so that if it becomes prevalent within a particular industry, so for example, if you're talking about how you keep their information secure, and it becomes very common for a padlock, for example, to be used next to it, then you should consider using those icons because they do act as visual prompts for people in terms of to pick out the bits of a privacy policy that they're actually interested in reading. So icons are actually very relevant. Moving on to data retention. Under the GDPR, there is very much a focus on looking at the data that you use within a business and considering whether it's excessive in terms of you need to only use the minimum data that is necessary to achieve your purpose. You need to have a look at how long you keep it for. So once data becomes out of date, then you need to get rid of it, which means that you need to set something like a data retention policy. So if you don't already have one, I would strongly advise that a policy is put together. Now, you'll see that I've made the point that one size doesn't fit all, and by that I mean that I sort of had a conversation with somebody a little while ago, and they said, it's fine, Joanne, because we have a data retention policy. So I said, well, what does it look like then? Can I see it? It's like, oh, you don't see it, it's 6 years. I'm like, oh, right, okay. 6 years in terms of a catch-all is not what I mean by a data retention policy. What you need to do is have a look at your different data streams and decide how long you keep it for. So if we go back to the Amazon example in terms of buying a book, they will capture my name and address in order to deliver that book. They will also capture my name and address in order to market it to me. Now we've already sort of talked about marketing consents and the need to refresh every 2 years. So from a marketing perspective, they can only keep it for 2 years. But from the point of view, if I have a problem with that product or problem with the service, then they would want to keep it for the limitation period in terms of the period during which they can be sued. So they'd want to keep it for at least 6 years in that context. So it's a matter of taking the data and defining what the purpose it can be used for a particular timescale. So I think it's a case of setting that out in a policy. One of the things you also need to think about in the context of data retention is secure destruction. And if you, I think it's worth putting it in the policy in terms of what your destruction position is. And if you use a third party, then you should definitely think about having a contract. We'll have a look at contracts. I think it's the next topic. But you also need to police what they're doing. And the reason I say that is because there's a situation that ended up in front of the ICO. And what happened was that a business engaged someone to carry out digitisation of their pensions records for them. So they gave them all their paper records, and they took them, and they did a great job in terms of, turning them into electronic files. But then they were left with the paper files, and it had been agreed that they would be destroyed. So what happened is that the task of secure destruction was given to the Office Junior. Now, the Office Junior decided that the best way to carry out secure destruction was to take it to the supermarket and use the paper recycling bin. So they trundled off to the supermarket and pushed it into the recycling bin. Unfortunately, it hadn't been emptied. So they pushed in as much as they could. They left some of it hanging out of the recycling bin and then left the box next to the recycling bin in the supermarket car park. Now, you can imagine when people found that and told the ICO what had happened, how well that played out. But ultimately, even though it was the Office Junior who had done something pretty stupid, the liability tracked back to the business because ultimately as data controllers they were responsible. The ICO took the view that you need to check and audit how people are carrying out their contracts with you. So if you are entrusting destruction to a third party, then you need to be asking the right questions. And certainly, I was talking to somebody last week, and they were saying that they actually followed the process so that when their sort of secure paper destruction stuff was collected by their supplier, they actually sat in the van, went with them, and watched what happened and documented it. Now, I'm not suggesting that you need to do that, but at least you need to be alive in terms of understanding what it is that they are doing. And certainly if you do fancy a day out at a shredding plant, then that could be a reason for doing it.
So just going back to that, Joanne, under that situation where it was the Office Junior, is an individual ever sort of seen as sort of liable for the breach, or is it always the kind of organisation? So now you obviously will look at tracks back to who's the data controller, etc. In that situation, I'm sure no one would wish to throw a colleague under the bus, but in that situation, if they tried to sort of say, oh, it's the Office Junior, it's the Office Junior, is there ever any individual liability that I should have done something and I did not do it?
No, certainly not at that sort of level of individuals like the Office Junior or whatever. Yeah, because generally, and it's the general sort of concept from an employment law point of view, is that in relation to your employees, what they do generally is regarded as something that you are responsible for, provided they are not off on a frolic of their own. And if he hadn't been given enough sort of direction as to what it was he was meant to be doing, then it will potentially track back. So no. And even the Data Protection Officer, one of the things that we'll talk about later, which one of the questions I get a lot is, if I'm sort of given the role of DPO, does that mean that I am financially liable for anything that goes wrong? And no, it isn't. They're not keen on sort of singling people out and throwing people under the bus. They don't like that at all. One of the things, just to flag while we're sort of talking about this, is that the Information Commissioner, whilst in a parliamentary committee, did indicate that she would quite like personal liability of directors in certain situations. But that hasn't yet got any traction. But it is a case of watch this space on that. But no, generally, I mean, to be fair, if there's a sort of like a data breach issue, one of the things that they will ask, and certainly I've seen this, is in relation to a member of staff that caused the data breach, have you taken any disciplinary action? And I don't think they're necessarily advocating that you do throw them on the bus, but they want to know that you are taking it seriously.
Okay. I think that's really useful, again, because, I've been in a recruitment agency most of my life, before joining to Pool, and I think often sometimes there is a perception that it's about individual responsibility. I think because everybody will tend to run their own desk and make lots of their own field, so I think it's a really valuable point that it's not that sort of individual liability.
Yeah. Looking at contracts are very important from a data sharing point of view. And you might be sharing data, and I think this is the point that we were talking about earlier, Belinda, in terms of you might be sharing data with somebody, and it might be you're a data controller, they're a data controller. It might well be the case that you're a data controller, they're a data processor. It equally might be the case that you are the data processor. And what you need in that situation is you need a written contract. It is a requirement, certainly in the context of data processors, and it is also generally a good idea in relation to any sort of data sharing arrangement, that you have a contract in writing, or at least evidence in writing needs to be in writing. So if you've got any informal arrangements whereby you've got suppliers and they are accessing personal data as part and parcel of the service that they're providing, that you find out if there is a written contract, because if it is informal and you don't have a written contract, then you're technically not currently complying with the Data Protection Act and you will not be complying with GDPR. So it's a good opportunity to essentially audit what suppliers you've got and check what contractual arrangements you've got with them. And if you don't have, formal contractual arrangements, then it's an opportunity to sort of pick up other things as well, like liability and stuff like that with them. And certainly, in the context of data processors, there are defined clauses that you have to have when you have a data processor or when you are a data processor in terms of what the content of the contract should be. Under the Data Protection Act, they look different to GDPR, and also under the Data Protection Act, if you are a data processor, you don't have to make sure that the clauses are there, the data controller does. But one of the shifts under GDPR is not only do the clauses change, but the responsibility to make sure that they are there sits both with the data processor and the data controller. So whilst as data processor before, you might have sat there thinking, well, I'm not going to volunteer for these clauses. From a GDPR point of view, I would suggest you need to be more proactive. The other thing I would say to you is that as a data processor, if you are pushing them from a proactive basis in terms of your contract with your clients in terms of the data protection side of things, one, it makes it look like you know what you're doing from a data protection point of view, and two, it also puts you in the driving seat of the contents of the clauses. So it may well be that your clients will impose them upon you. It may well be that you could go to your clients to say, this is what we're suggesting, what do you think? But I think you need to at least be alive to this issue, whether you are engaging a data processor or whether you are a data processor. What that means is that any existing contracts will need to be varied, potentially. I think it would be unlikely that the contracts cover everything that is required from a GDPR point of view, so I would have a look at them, pull them out of the cupboard, and I would vary them. If you are entering into new contractual arrangements, which are going to run past May 2018, then I would advise that you include a two-tier data processor clause now. And essentially, the first part of the clause says that this will apply up until May 25th, and then the second part of the clause says that this will apply post May 25th. You could try and impose a fully sort of GDPR compliant clause now, but I can tell you from experience that doesn't really play out well and people aren't really very keen on them. You're much more likely to get traction in terms of having a two-tier processor clause, and people do see the logic of doing that. Something you sort of said to me the other day is, well, what we've said is that we're going to potentially look at it when GDPR definitely happens. And you sort of can do that, but then you're going to be scrabbling around varying at the end. So I really would say if you're entering into new contractual arrangements, then consider the two-tier processor clause.
And Joanne, can I ask, recruitment agencies, again, there's just so much data flowing through, and increasingly we have like scans of stuff and images of this and that. GDPR is obviously about what are you collecting, why are you collecting it, what are you doing with it. Does it also delve down into almost the integrity of that data?
Yes.
Okay.
There is an obligation to do, essentially for your data to be accurate and for you to have a process to enable you to update that data, so that if somebody comes along to say, oh, that information's wrong, that's not my date of birth, or that's not my NI number, or whatever, is that you need a process to promptly update that. And one of the things that I think you should be evidencing from a compliance point of view is what that process would look like, and in terms of, is there a defined person, how quickly will you aim to turn it around, and sort of things like that. So yeah, data integrity is important, because one of the things that they recognise is that unfortunate decisions can be made in relation to individuals on the basis of inaccurate data, and so you're entitled, particularly in these days, in terms of what decisions are made on the back of data, for your data to be accurate.
And again, I think that's really key for everyone on the call, because again, thinking back to my days, far too long ago now, to remember when I started off as a consultant, and the volume of data that each candidate attracts is enormous. The number of systems that might be held on, the number of places on the record card, and as you say, if you've got certain things wrong, and that person then potentially misses out on being selected for a role because skills haven't been perhaps updated, in fact where they might be down on skills. So all those things you would very much need to try and ensure that they're as robust as possible, as you would hope, obviously anyway, but also, as you're saying, have a process for immediately correcting them.
And I think if you've got multiple systems, I think one of the challenges that people are facing is quite often there've been systems that haven't they don't talk to each other. So essentially what you need to do is at least have a process that if you need to correct it on one, that either it will correct on all, or that you do have a process where you go and manually correct on all. Because what you don't want to do is update one and not the rest, because that's just going to lead to maximum confusion in that situation. But no, data integrity is very important. One of the other things that I would suggest to you in relation to suppliers that you are engaging is that you consider asking them now what their GDPR readiness is. So if they are engaged by you and have access to personal data, is that you ask them in terms of what they are doing, because I think it gives you a snapshot in terms of, are they appropriate in terms of continuing from a, are they ready from a GDPR point of view? And you can ask a simple question. You can ask them what their plan is in terms of what they're doing. You could also potentially submit a questionnaire, and I think in certain more sophisticated arrangements or where there's a lot of data crunching, then questionnaire is a good idea. I think it also should form part of your procurement process while we're talking about contracts, so that if you are engaging a new supplier, I think information security and data protection compliance should be a question that you are asking if they're going to get access to your personal data. Because if you think about how it's going to play out with the ICO, if something goes wrong and they say, well, did you ask this supplier what they were going to do, or how they were going to store the data, or what their information security was, and you say, no, never thought about it, then it's going to track back to you in terms of not having carried out the right DD. So I would very much encourage that you start asking questions, that you start building these sort of things in from a DD point of view. You also may want to take control of the narrative with your clients in terms of explaining to them, or having some comms prepared, if you are asked the question, what you are doing from a GDPR point of view, to say, this is what we're doing, this is our timeline, we think we will be compliant by whenever. Because I think potentially if you take control of the narrative, then it may well be that they have the confidence in you and you don't start getting very detailed questionnaires. And so it is something worth thinking about. And I think comms from a GDPR point of view are really, really important, because they do set the scene in terms of where the business stands, and also internal comms as well. I'm very keen from a compliance point of view that there are internal comms, because the last thing you want is that one of the clients phones up and asks one of your members of staff, what are you doing? And they go, well, I don't know. What you need is that everyone is singing from the same hymn sheet, and that they can sort of tell people, particularly because obviously you're in a very data-driven business, what your GDPR compliance program looks like.
And it's probably worth saying at this junction, obviously in the next sort of 40 hours, we'll send through obviously what the pool are doing. We'll send you through a fact sheet, and slides will be on there. That's part of the reason we have organised discounted legal advice fees for potential projects, etc. So that we are very aware that some of you will be supplying some really big clients through to pool, and other really big clients outside of obviously our portals and our frameworks. And I think the questions will be coming. They haven't quite come in yet, I don't think, but I think they are. People are really getting aware now. And obviously one of the reasons we wanted to run this training for our agencies is because whoever you're supplying to, whether it's through us or not, it is something that will impact every area of your business. And I think the more that the recruitment industry can show it's on the front foot, I think that's really positive for us as an industry as a whole, because we have so much data. We're probably one of those industries that, has as much data as your Tesco's or your Sainsbury's, the people that run the Nectar cars, or, that sort of thing. And I think that it's a real opportunity to show, that recruitment kind of really needed its way with this, and get the head around it, however big or small you are.
And to be fair, Belinda, we've spoken to a number of recruitment agencies, and it is a concern. People are genuinely wanting to do the right thing, and there is a perception, as I was sort of saying at the outset, and certainly we've seen a lot of it from the carrot point of view, from a recruitment perspective, that people are wanting to set themselves ahead of their competitors by saying, we take it really seriously, we will be compliant, and we'll make sure that we are publicising that. So yeah, I do think comms are very important. Looking at training and the role of data protection officer, training is really important within a business. I think there is a bit of a perception that it's a bit of a cherry on the cake and it's not really that important. But training can make the difference between being fined and not being fined. We recently advised in relation to a data breach issue, and it came from a phishing email that was received by a member of staff, and they were asked to click on a link and to feed in their creds to the system, which they did. And to be fair to them, it was a very convincing email. When I saw it, it was very cleverly done. And that opened up the system, or certain parts of the system, to some hackers. Now, they self-notified to the ICO, and we'll have a look at data breach in a minute, but essentially, when the ICO was looking at the situation, and we were trying to convince the ICO not to fine, we did make it very clear what level of training everyone had, and that we could also track that individual member of staff had definitely been trained, and we could pinpoint the date on which they've been trained and what they've been trained on. Now that was really important, because that level of training and the fact that we knew that that member of staff had been trained, and the policies surrounding that training, and also what they did following the data breach, but sort of the training was one of the things that factored in, and was one of the reasons that the ICO specifically referenced as being the reason why they were not going to fine. So they got a slap on the wrist and they were told to fix certain things, but they were not fined. So I do think training is very important. I think all staff who have access to personal data need a level of training. Anyone who has a lot of access to personal data potentially needs enhanced training. And I would definitely suggest that you have a policy on training, and that you maintain these training registers as to when training is happening, what training it is, and when it is refreshed. Because as I say, if you have a data breach, it is very, very helpful to be able to prove what happened, who was trained, when they were trained. Looking at the role of DPO, there is a lot of, there's a lot of misconceptions, and I actually see articles out there generally on various websites and things in relation to DPO, and some of them are saying it is imperative that all businesses have a DPO. All businesses do not need to have a DPO. It's a question of making an assessment. Essentially, if you are a public authority or you are a business that crunches a lot of data, then you should have a DPO. To be honest, I think in relation to recruitment businesses, I think it would be a good idea to have a DPO, because as sort of Belinda was saying, in terms of the amount of data that you will have and what you will do with that data, I think a DPO is a good idea. And the one thing that I would say to you is that you can't be wrong for having a DPO, but you certainly can be wrong for not having a DPO. And I think there's also some misconceptions in terms of what a DPO is. It doesn't have to be a full-time role. Essentially, if you are a small business, it may well be that it's more appropriate that you have somebody combining it with another role, and that the query over the level of expertise, and that sort of depends on the amount of data, the size of the business, volume of data. And it may well be, you don't need anybody with a lot of fancy qualifications. Essentially, if somebody's got throughout in terms of experience on the job of dealing with data protection, they may be suitable. But I do think in the recruitment area that a DPO would be a good idea. Now, in terms of killing off a few other myths in relation to a DPO, the first thing is that they are not the sacrificial lamb to the ICO.
Very lots of people will be disappointed by that on the call. We'll just get a DPO, we'll be fine.
Well, I think there is a bit of a perception of that in terms of, I'll tell you what, why don't you be DPO? And then sort of with the idea that if anything goes horribly wrong, then everybody can just sort of point the finger and sort of throw them under the bus.
Yeah, that's unfortunately not the option.
No, that is very much not the case. They are meant to be there as the focus point of DP activity, auditing whether or not policies are being adhered to, and making sure that training registers and things are kept. Now, for anybody that has been put in the frame of being DPO and is concerned about it and might not want to be, you might be quite pleased with the next part of the comments that I'm going to make, in that whenever I sort of present this, quite often there are people in the room who have been asked to be DPO, and when I explain about the independence requirements, then you can hear an audible sigh of relief in the room. Essentially, a DPO has to be independent. What that means is you should not be marking your own homework. If you are in a role that decides what data is collected and what is done with it from a strategic point of view, rather than doing what you are told to do with data, then you are not suitable to be DPO. So if you're HR director, finance director, CEO, chief information officer, roles of that, marketing director is the other one. So if you are in roles of that nature, yeah, you're all right, then you are not suitable to be DPO. It has to be somebody that is independent, but it can be somebody within the business. And certainly in some organisations, that's falling to people who already deal with compliance or in-house legal, or it's someone else that is willing to sort of take it on as part of their role. One of the things that I would emphasise, though, is that there needs to be, whoever it is, there needs to be a path through to the management, in terms of the highest level of management, because if there is an issue in terms of a non-compliance within the business, and they need to get it to board attention or sort of senior management attention, there needs to be a way through, and that can't be through about 4 different layers of other people who can potentially sanitise what it is that they are saying. If you operate on a group structure, you can have one DPO across the group. And the one thing I would say, though, is if you operate on a multinational group basis, they need to be accessible internally and be able to speak the language of all of the members of the group. So I act for a company that has places of business in the UK, Germany, Switzerland and Austria. So their DPO, if they're going to choose one, would have to be able to speak certainly German and English, and possibly some other languages. So they're actually opting for each individual company having their own DPO, but I just sort of throw that out there. You can also engage somebody to do it on the basis of a service contract, on a consultancy basis. The one thing I would caution about that is, certainly if people are sort of offering DPO online or something like that, they're not sufficiently embedded within the business to be able to find out if there is compliance with data protection policies, or to be able to track training, or to have proper access to management in terms of being able to report on what's happening with the business. I would query whether or not they are actually acting as DPO.
That's almost like a box ticking exercise, yeah. And the whole purpose of this law is, yes, you've got to do A to Z, you've also got to abide by the spirit. So that kind of sounds like, yes, well, it sounds like someone trying to make some cash as well.
I think you're right.
Probably not that fit for purpose.
Yes, I think people are trying to make some money out of something, and you could have a problem. You'd be better off having somebody internal that has got the right support with the policies and things, than just sort of doing that, because I think if anything happens, the ICO will not consider that to be adequate. Privacy impact assessments. They are not something that is incredibly widespread at the moment. Essentially, it's an assessment of a new product or service or system, and a consideration of whether or not how it uses personal data, whether it's excessive or whether it's appropriate, and on whether any modifications should be made to make it more appropriate in terms of minimising the impact on privacy rights. There is some guidance issued by the Information Commissioner in terms of when a PIA or DPIA, you pick your acronym, should be done, but they are not. They are done in some sort of businesses, but they're not incredibly widely done. Under GDPR, it will be compulsory in certain circumstances where there is a high risk to the rights of individuals, and there is some guidance issued by the Article 29 Working Party in terms of an indication of what that might look like as to when you need to do one. There's also a template attached to that document as well as to what a PIA should look like, so it's probably worth having a look at it, although you probably will have to tailor it for your business. So the sort of situations that they're talking about is, for example, if you are using automated processing to make decisions in relation to employees. So if you were going to make redundancy decisions and you were using a fancy algorithm to do that and there wasn't any sort of human intervention, then you should do a PIA, because I think they're trying to flag to you that not considering any external sort of things or having the human touch on that is probably not your greatest idea. So if you are involved in something like that, then doing a PIA is something that is recommended. The Information Commissioner can issue guidance as to when they will be required. We don't yet have that, but it's probably worth watching this in terms of whether or not there will be prescriptive situations where it will be needed. They should be started pretty early in terms of if you're coming up with a new system or a new service, I would do it early. And somebody said to me that they'd probably leave it till a few weeks before launch. I sort of suggested that that wasn't your best idea, because if you've set a launch date and publicity and things like that, if you're going to have to pull it because you've got privacy concerns, not your best idea. It does need to be refreshed, so it needs to be thought about at least every 3 years, and certainly if the project evolves, you should think about it. But you can do it across a number of projects as well. So if, for example, you were going to carry out, let's take the redundancy example, if you were going to carry out that sort of redundancy process on a number of occasions, you could rely on a single PIA. One of the things that I would say to you in relation to PIAs is that when I was talking a few minutes ago in relation to building data protection into your procurement process, is that if you're engaging somebody to provide a service on your behalf, which is very sort of data heavy, or you're buying a product in, so you're buying some software in, which potentially is going to sort of capture a lot of personal data, then you could ask the vendor whether or not they've done a PIA, and you can rely on that vendor PIA as being compliant, subject to you topping it up in terms of how it will be implemented within your business. So again, I think looking at your procurement process is a good idea, and that's worth asking vendors in terms of whether they've done them. The slide here, the primary reason why I've put it up rather than to talk about it in detail, although you will get it in your slide packs, which Belinda has mentioned, is that essentially it shows that it's circular and it's forever going round, so that essentially you do need to review it and you do need to rethink it as and when the process evolves. Moving on to what the hurdles or bumps in the road potentially look like from a GDPR point of view. As you can imagine, in terms of the context of personal data, individuals are really the main hurdles that you will face in terms of what it is that they are wanting. And there are enhanced rights given to individuals under GDPR. Now, you will probably be familiar with the idea of subject access requests, where an individual contacts you and wants details of the personal data that you hold on them. They are currently relatively common now, and certainly we are seeing them on the increase, and they are increasingly used in the context of disputes or potentially employment claims, but we are certainly seeing that they are becoming more and more prevalent. At the moment, you have 40 calendar days in which to respond, and you can charge £10 to individuals if they are wanting their personal data. Under GDPR, you will get a shorter timescale in which to respond, so you're only going to get a month, and you cannot charge a fee unless it becomes a vexatious request. You potentially can get an extension of time if it's a complex request, but the one thing I would say to you is make sure it's genuinely complex before you go down that route, because if it ends up in front of the ICO on a complaint because you've not responded and the ICO does not agree with you that it is complex, then you potentially got an issue. And one of the things that I would very much say to you in the context of subject access is do not miss the deadline. Even if you provide all of the information, if you are late in providing it and a complaint is made to the Information Commissioner, you are likely to receive a letter from them saying that yes, you have complied with the request, but you are in breach because you are late. Now, what they tend to then say is that they will keep that on record, and should there be any other data protection issues which come to their attention, then they will factor that in terms of deciding what they're going to do in the future. Now, it's not a black mark as such, but it is putting you on the ICO's radar. And I would definitely recommend that you do not put yourself on the ICO's radar. It is not a place that is very comfortable to be if you potentially are going to get further complaints or subject access requests. The right to data portability, essentially, portability is the ability for individuals to get a copy of their data or certain parts of their data, the data that they have given you, so not that which you have put together, in a format to enable them to move it. It's limited because it's data they've given to you, it's only where you are processing that on an automated basis, and it's only where you are using the gateway of necessity to perform a contract and consent. So if you add all those things up, it's really not that detailed, it's not that wide-ranging, sorry. So I think there's a lot of businesses concerned about right of data portability, but I don't think it's going to hit a lot of business. The right to be forgotten, however, I think will have an impact. And I think it'll have an impact for all the wrong reasons to some degree. In that I don't really like the title, and the previous Information Commissioner, he didn't like the title because it's misleading. And there is a press sort of misconception as to what the right to be forgotten is. I even saw it, and bizarrely, there was a discussion on the right to be forgotten in Elle a few months ago, which for a fashion magazine was a bit of a bizarre in terms of worlds coming together. But anyway, there is the press take on the right to be forgotten is that essentially you can remove your dodgy credit history or the fact that you are in debt or haven't paid a bill at the click of a button. That is by no means what it is there for, and it is very limited in scope, as you'll see from the slide. So essentially, in my view, the right to be forgotten means that you are bundling together rights that you have probably under the Data Protection Act anyway, on the whole, and sort of giving them a snazzy new title, which is actually quite misleading. So, for example, you have to access the right to be forgotten and erase data where the use of the data is no longer necessary. But if you have the right retention policy, it should have gone anyway. So you shouldn't be in the realms of people making requests on that basis. Similarly, we're back to our old friend consent. If you are processing personal data solely on the basis of consent, and that is withdrawn, you've got to stop using it. But that's something that's the case anyway. So it's the nature of consent. So there's not a huge amount of stuff that's new. One of the things that probably is new is that they can object to you processing their data on the basis of legitimate interest. But essentially, I think if you genuinely do have legitimate interest, it's a matter of going back and sending a standard letter to say that you think you're entitled to do that on your legitimate interests. And this is why. I think the problem that you will potentially find in relation to the right to be forgotten is that people will try and exercise it where they have no right to be forgotten. And I think it's important to potentially have people within the business trained so they know how to respond, and also to have maybe some standard responses to go back to people. Now, I thought, because we act for some clients in the sort of credit space and debt space, that the first time I came across the right to be forgotten, it would be in the context of those clients, in terms of, I already know there are websites out there in terms of how not to pay your debts, use the right to be forgotten. But that wasn't where it came from. I have come across it already. And what happened is that a business had used payroll in the office, and they'd used a computer in the office, standard license arrangements. And what they decided to move to was a cloud-based arrangement. Now, somebody on the factory floor did not like that, and they decided to send a letter to say they were withdrawing their consent to them being paid via the cloud solution, and also that they were exercising their right to be forgotten. Now, as you can imagine from what we've already been talking about in relation to gateways, consent wasn't the gateway that allowed that payment to be made to them via that system, so the consent thing was a dead duck, and also the right to be forgotten. The grounds that we were just talking about don't apply in terms of it wasn't consent-based processing, the data wasn't out of date, none of the other things applied in terms of it wasn't unlawful, so they had no right to be forgotten. The difficulty with it is, and the reason why I sort of flagged that as being something as to where I first came across it, is that it came completely left field. And what it meant was that it had already been to the HR director, been from the HR director to the managing director, then gone from the managing director into us to provide legal advice on it. Now, it's really the irritation factor, I think, is what I'm saying to you in relation to the right to be forgotten, in terms of being prepared to deal with people that think they've got a right that they don't have. The difficulty you will have, and I will be honest with you, is they will believe the Daily Mail that they have got the right to be forgotten, rather than when you are trying to explain to them that they don't. But I still think there needs to be internal training, and it's a management of how to deal with those requests, and probably they are without foundation.
And that's going to be really key in recruitment, because we do have awkward candidates sometimes, and also sometimes we have litigious candidates. So I remember when the Age Discrimination Act came in, there was all a big flurry of people watching to make sure, they answer this, they answer that deliberately to try and ensure that they can sort of trip you up. So I think that's a really, really pertinent point about making sure you do know, who would deal with that. And presumably, Joanne, if they email in and say, oh, I don't want you to have my data anymore, and that's proven to be true, you literally have to delete every scrap of information you have. They don't have to say, oh, they don't have to specify, they just have to say, I want you to delete my candidate record or my data.
I think the thing with it is, Belinda, and I think the question as to what you want to do about it, is you've got to delete the data. So, for example, if they're going down the consent route, so the data where you are processing it on the basis of consent, you've got to delete. If you are keeping it for some other reason, in terms of, for example, they were sent to an assignment and it didn't work out, and it was because of their behaviour and things like that, and you were saving it from the point of view of making sure that nothing came of it, then you are not doing that on the basis of consent, so potentially you can keep that. So I think it is quite, sometimes it'll be easy to deal with, but I think sometimes you need to take a step back and think, well, hold on a minute, what does it apply to? What do I have to get rid of, and what do I keep? And the other thing I think which is relevant is potentially maintaining suppression lists. Now, certainly current practice with the ICO, sort of from a marketing point of view, or sort of promotional messages point of view, is you should maintain a suppression list, so that if, for example, you get data from elsewhere, you're not inadvertently sending it to somebody that's already opted out of it. Now, one of the things that's not clear from the right to be forgotten, because the recitals in terms of the front end of GDPR is different to what the content of the actual article, which is the legal part, says, which is incredibly helpful. But certainly I think the ICO will come down on the basis of suppression list, because if you don't maintain a suppression list and you get the data in from a different source,
how do you know?
You've not exercised the right to be forgotten. So I think
you can put them back on again. Yeah, because I guess once they've said no, if the data accidentally comes back in again, it's up to you to make sure it has gone and it's never coming back, essentially.
Yeah. So I think that's going to be interesting to see how that sort of pans out, certainly from a marketing point of view. But I do think you're right. I think it is an industry where you will find out you do have awkward individuals that will be purporting to exercise all sorts of rights that they don't have. And again, I think it's something that you need to be teed up for, and to think about how that might impact, and therefore what you would do with it. So if you do engage somebody to be DPO, and then that's something that should very quickly go to them. Data breach is another key aspect of GDPR. You need to plan for data breach and understand what you would do. And the reason for that is that it is going to be compulsory under GDPR to notify potentially both the ICO and the individuals affected if there is a data breach. It's not currently the case that you have to notify a data breach. There is a code of practice and some guidance which does apply, and they do encourage self-notification of serious data breaches. But it will be compulsory under GDPR for certain circumstances. Now, you'll see on the slide that there are two different tests for notification. So potentially you might have to notify the ICO rather more than you will have to notify the individual concerned. So the ICO, you'll see that the test there is if there is a data breach, you have to notify unless you can show that it's unlikely to cause a risk in terms of to the individual's privacy rights. To the individual, you've got to tell them where there is a high risk to their rights. So, for example, identity theft, as you'll see on the slide. So it's more likely that you will be notifying the ICO. Now, you have to notify the ICO within 72 hours. And I'm quite often asked the question in terms of, well, is that 72 hours from when it happens, or is it 72 hours from when you know about it? Now, obviously, you can't notify what you don't know. So it does run from when you know about it, but obviously you need to move fast if it's something that has been festering away within the business for a period of time. And one of the things that I would encourage in the context of data breach is to make sure that you have an internal culture, that people will notify any form of data breach, so you can make the assessment in terms of whether or not it is notifiable or not. Now, one of the things that I think this should be picked up in training in terms of the importance of, letting people know if they have had a data breach internally, is that it is, obviously things can sort of spin out of control if you don't know that. And I think one of the other things that needs to be picked up is an understanding of what a data breach is. So data breach, there is a very much a perception that data breach is hacking. And to be fair, if you are interested enough to have a look on the ICO website, they've done a nice pie chart in terms of where a lot of data breaches are coming from these days, and sort of cyber liability and hacking and things like that, and phishing emails, certainly are on the rise in terms of causing data breaches. But you also got to understand that data breach covers things like leaving a laptop in a bar, leaving a file in a bar in terms of paper file, potentially, in the scenario in relation to leaving a box of pension details by a recycling bin, that sort of thing. It also covers things like people giving information over the phone. So we had a situation a while ago, quite a long time ago now actually, where somebody had booked to go to an event, and somebody contacted the box office and said, we think that Mr. and Mrs. Bloggs are coming to this event. Can you tell us whether they're coming, what date they're coming, what time they're coming, and where they're sitting, please, because we'd like to sit near them. Now, the box office were trying to be incredibly helpful, and so disclosed all of that information and also booked the seats behind. What box office did not know was that essentially there was a family feud. And so Mr. and Mrs. Bloggs had gone for their wedding anniversary, and the people behind were like brother and sister-in-law or whatever, and they had gone to deliberately disrupt their night out and cause maximum sort of disruption. So that led to a complaint. And that sort of being helpful over the phone and disclosing information can comprise data breach just as much as hacking. So I think staff need to be alive to that issue. And that's something that does need to be picked up in training. In relation to notifying individuals, then there are certain exemptions when you don't have to notify the individuals. And the first is where there is essentially technological or organizational protection. So, for example, encryption. My laptop is encrypted, and when it is logged off, I am assured by my IT team that it's about as useful as a doorstop. There's also the second one, which is sort of the controller has taken action to eliminate the risk. So, for example, if I were to leave a document in a bar, a file in a bar, and I was with a colleague, they saw that I'd wandered off and forgotten about it, picked it up, and nobody in the meantime had managed to get hold of it, then that would have been taken action to make sure there was no risk. The third one I would call PR suicide, in that disproportionate effort. Yes, you don't have to send out individual notifications, but if you are going to rely on that, you do have to make a public statement. So essentially, rather than sending out individual emails, you are taking out an ad in the Daily Mail or something like that nature, which is never a good thing. So that's why I would consider that to be PR suicide. Just to flag with you that on top of GDPR, the government is already tinkering with things. There is the Digital Economy Act. You'll recall that I mentioned earlier that the process of notification was going, so that you didn't essentially fill in the online form and pay your money. There will, however, be a fee, which is a UK government choice. So those fees will be ready for May 2018, but we don't know what they look like. I've put on the slide that it's sort of big numbers, but that is essentially scaremongering by various people that have essentially added up the number of new staff that the ICO want and what the wage cost might be, and sort of done a calculation. So I wouldn't worry that it's going to be around that for large data controllers. I think it won't be. The other thing that this piece of legislation does is that it requires direct marketing guidance to be issued. And so on the basis that it is required to be issued by statute, if you have a breach and it relates to breaching that guidance, then it's not going to play out well with the ICO. One of the other things to mention is in relation to the Data Protection Bill. As I said, it will confirm that GDPR is happening. It is also going to include some sort of bells and whistles on the top. So, for example, it will say that people under the age of 18, when they reach 18, have the ability to have their social media wiped, so that they essentially start fresh in terms of anything that would be unfortunate on their social media profile.
Like all the pictures we post of our children. That's why that's coming in. All those, here's this picture of this child, you know, doing something they shouldn't do at the age of 6.
So, yes, that is sort of stuff that is going to sit on top. So you just need to be wary that the government appears to have an appetite for adding to GDPR. So we just need to sort of watch this space on that one. The other thing I'll flag with you, but I'm not going to go through in detail, is anybody involved in marketing via SMS or email to individuals, is that the current regime of the Privacy and Electronic Communications regulations will be superseded by the e-privacy regulation. The text of it hasn't been approved as yet, and they can't make their mind up whether they're aiming for May 25th, 2018. They keep changing their mind on that. But the thing to bear in mind with it is that the fines under that regime will be the same as GDPR. So there will be big fines under that as well as under GDPR. Moving on to what the fines look like, as I sort of raised in the beginning of the presentation, the fines are going to be a lot bigger than they have been. Currently, the maximum fine the Information Commissioner can levy is $500,000. Under GDPR, then you've got a two-tier system. In relation to minor or administrative breaches, essentially the maximum fine will be 2% of global annual turnover, or 10 million euros, whichever is the larger. And for the sort of more meaty things, in terms of things like data breach, then the maximum fine is 20 million euros, or 4% of annual worldwide turnover. So they are big numbers. One of the things that we don't yet know is what the ICO's appetite for fining will be. But one of the things that I would say to you is certainly 2017, their appetite seems to have increased somewhat from 2016. And there have been some fines levied in areas where I was a bit surprised. So, for example, when we were talking about people coupling marketing messages or sort of marketing preference information on updating names, addresses and things like that, and service messages, I was surprised that they fined in that situation. I thought they may have said, don't do it, and sort of issued it in terms of, please don't do this. But no, a fine was levied. And also, there has been a fine imposed upon a small business that filed small business accounts in relation to having inadequate security. And certainly there has been a perception for quite a long time that small businesses can sort of get under the radar in terms of they won't sort of trouble the ICO because the ICO are only interested in big fish. That's not the case, and the ICO issued a statement to accompany that fine and basically said, we're using it to send a message. You are not too small to be under our radar. So it is something that I think you do need to bear in mind. And you'll see there that I've mentioned Italy. Italy have recently already levied a fine of 11 million euros. So some big fines being issued. In addition to the possibility of being fined, you could also be sued. So an aggrieved individual could decide that they are going to sue you for their damages that they feel that they have suffered for your data protection breach. Originally, under the Data Protection Act, you had to demonstrate that you had suffered financial loss before you could bring any claims for things like damages and distress. The courts have driven a coach and horses through that in the decision that I've mentioned on the slide. So what was happening in that situation was that Google were essentially monitoring what Safari users were searching for. Some people got wind of this, and notwithstanding the fact that it hadn't caused them any financial loss, they decided to sue. Now, the court agreed with the individuals that even though they'd suffered no financial loss, they could recover for their distress. So the law has already changed, but certainly it will be absolutely put to bed by GDPR, which says that any damage suffered can be compensated should an individual suffer any loss as a result of or damage as a result of GDPR breach. So you do need to have one eye on that. One of my colleagues who is a litigator has said that they have heard on the grapevine that there is potential for there to be a group action arising from a data breach, and that's sort of in the wings at the moment. I don't know whether that is the case, and only time will tell to see whether or not that action is actually issued. But it is something worth thinking about in terms of you could also be the subject of a damages claim. One thing I will flag with you, though, that you need to be alive to is that you may well get quite a lot of spurious claims as well. I got sent something the other day by a colleague to ask my opinion on, and what had happened was that an individual had registered on a mailing list, a marketing database with 3 slightly different names, and they asked for one of their names to be taken off. So they continued to get, obviously, emails in relation to the other 2, and then they complained. And they sent an email to say that they were going to complain to the ICO, but they might call it quits if our client decided to compensate them. And the things that they wanted compensation for were use of their electricity, time spent downloading and reading the emails, use of their data in terms of getting hold of the emails, and other sort of ridiculous sort of list of things that they wanted compensation for. So you do need to be alive to people will sometimes try it on. As you can imagine, we politely declined on the basis that the client didn't consider that they'd done anything wrong, and that if they wanted all 3 names to come off the mailing list, then probably they should have mentioned all 3 when they sent their request to be removed. So finally, and in summary, essentially what you need to do, as I say, you need to understand what data you've got. When you've got a feel for what you've got, you need to understand how it's permissioned and what gateway will apply to it. If you are in the realms of consent, which, as I say, I would try and shift down the list unless you're in the realms of marketing or sensitive personal data, then you need to look at what your consents say, because the content of consent has changed quite a lot under GDPR. You need to have a think about transparency in terms of, are you clear with people how you are using their personal data? So that means you're going to need to revise your privacy policies and fair processing notices. You will need a number of new policies. So I've suggested on there a data retention policy, a data breach policy. There are a lot of other policies that I would also suggest. I think you need to take a step back and think about all of those things that you may well need from a data protection point of view, and increase your documentation. You need to think about your contracts. You need to find any contracts that you have with suppliers who would be regarded as data processors. You need to make sure that they're varied, or that your current new contracts have got the right clauses in. And you need to carry out staff training. As I said to you during the presentation, I think staff training is very, very important. I think it can make a big difference should a complaint be made. You need to think about whether or not to appoint a DPO and who that should be. As I said to you, I think in the recruitment arena, I think a DPO would be a good idea, because obviously you're operating in very data-driven businesses. You need to think about what rights individuals will have and how you would respond to things like the right to be forgotten or the new regime in relation to subject access requests. And you need to think very hard about what you would do in the event of data breach. I think planning and sort of some thought as to what you might have to do is going to be really important should you have a data breach, because it will enable you to send in the notification to the ICO in a timely manner. The other thing I'll say to you in terms of what you send in is you need to position yourself in that rather than just have a data dump in terms of providing a load of documents, because you need to think about what you are saying and what you are conveying to the ICO. So being set up for a data breach in terms of thinking about what you would do in escalation is very important. So that's it in summary. Obviously, we can't take questions on live. We can't take questions on the phone. But if you do have any questions, then please would you submit them to Belinda, and then she can circulate them. And thank you very much, everyone, for joining today.
Yeah, thank you so much, Joanne. I have to say, I'm always in awe of the fact that, let's face it, data protection, as you said at the beginning, a little bit of a dry topic, and you have given this presentation a number of times, not only for us, but obviously I know for lots of other interested people. I'm literally in awe that you always make it so fresh, so interesting, and I think, most importantly of all, so pragmatic. I think Irwin Mitchell is a law firm that is very well known in the recruitment sector, actually, and they do a lot of exhibiting with Recruiter Magazine, etc. And I think one of the things that has always impressed me over the years whenever I've heard anyone representing the company speak is how much you get the recruitment industry. It is a fascinating industry. It is an industry that has a lot of twists and turns to it. There's a lot of data that flows through, and I think to have someone come on and sort of just give really simple, straightforward advice on what is a very complex topic and set it into context is invaluable. So I hope that everybody has enjoyed this. Since we did the management buyout at DePaul, we're very keen to open new ways of working with our agency partners to ensure that we're supporting you as much as we can with things like new legislation. If you have any feedback from today, please either drop us a line when we send through all the slides and the info and all of Irwin Mitchell's details and information about these, should you wish to work with them more, or drop an email through to info@depaul.co.uk. That's info@depaul.co.uk. Thank you so much for joining us, and thanks once again to Joanne. It really has been a very enlightening seminar today, so thanks, Joanne, and thank you all.